Good morning and welcome to Cyber Jurors for the Cannabis Industry. We have here with us today Tyler Gerking, the head of our insurance recovery department at Farella, Braun, and Martel, Nate Garhart, who is our privacy guru here at Farella, and I am Shanti Eagle, and I'm also in the insurance recovery group. And we are joined today by our friends Javier Gonzalez and Michael Peters, who are at PL Risk Advisors. Javier is the Principal Executive VP, and Michael Peters is the brokerage leader for cannabis. And I will give them just 1 minute to tell you a little bit more about PL Risk Advisors.
Thanks, Shanti, and appreciate you guys having us today. Appreciate everybody who's listening in as well. So PL Risk Advisors, we are a national wholesale and insurance broker. All we do is professional management liability and also cannabis P&C coverages, and we operate in 49 states.
Perfect. So my name is Michael Peters. I head up our wholesale cannabis insurance division. We really appreciate Shanti, you setting this up, and Tyler and Nate, thank you so much for joining today and getting the ball rolling on this. I think, as we all know, cyber insurance is increasingly important topic of coverage when we get out there and start working with our different insureds, regardless of industry. But I think for a lot of people, there's kind of been this perception that somehow maybe cyber is not as big of a deal within the cannabis industry as, say, other industries. But the reality is, and we can jump to the next slide. Shanti, you can go down to slide 6 if you'd like to at this point. The reality is that we're starting to see the advent of more and more cyber-related incidents within the cannabis industry as a whole. What makes this particularly worrisome, especially within cannabis, is the fact that we're dealing with industries that are both manufacturer, client-facing, retail, but then also we have situations where we are looking at this from a medical standpoint. And as you can see here from this first slide, there are a number of incidents that have come up recently. We see, a couple of well-known companies within the cannabis industry that have been hit with recent cyber attacks, whether that's ransomware related, whether that's data breach, whether that's protected information for different clients. And as you can see, just in 2020 alone, as we look at the statistics relating to cyber events, we're looking at significant increases in the propensity and severity of these events. What we can see here on this slide is that, cybercrime as a whole has increased roughly 600% since the beginning of the global pandemic. This probably isn't a surprise to too many on the phone or on this video conference because, in years past, this might have been an in-person event. So I think that we've seen a lot of changes to the way that we conduct business. And that's, our cannabis clients and cannabis businesses are not immune to this shift. In fact, when we look at ransomware, we've seen, they're accounting for roughly 41% of cyber insurance related claims. And, I can assure you, and I'm sure Javier can attest to this as well, that increase in ransomware and just the general payouts that are occurring. I mean, we've heard of some recently that were quite staggering. Within the insurance industry, we've seen it within the pipeline industry. It's really nobody's immune. I think I saw today an article came out that meat packers were now being targeted by ransom-ish attacks. So we don't expect to see this decrease anytime soon. And the other reality is that as we've continued to shift towards a more remote work environment, we're seeing some lags as it relates to compliance, as it relates to implementation of different risk mitigation strategies within the cyber continuum. So here's a slide that indicates some of the claims that we've seen. This is going to be a frequency-based slide. So when we look at industries that are most highly targeted, we're looking at consumer industries, we're looking at energy, we're looking at healthcare, we're looking at industrial, IT, et cetera. And I think that, one thing to keep in mind is that cannabis itself can find a home in a lot of these industry types. It's not segmented off to one or the other. So believe it or not, we have a lot of moving pieces within the cannabis continuum that are going to drive claims frequency and severity. What are we seeing that's new to cyber overall? First off, we're seeing a lot more social engineering and spear phishing attacks that are being targeted towards employees. We're not just looking at C-level executives these days that are the ones that are going to be involved in these ploys. We're seeing state-sponsored actors. We're seeing hacktivists. That's one of the issues that we're starting to see a little bit of that would affect cannabis. We're looking at regulatory risks that are continuing to expand. There's obviously a lot of different state jurisdictions. And can you go back just 1 second, Shanti? One of the things that I'd like to identify in this slide that I see as important is PHI. This again deals with HIPAA compliance. It deals with protected health information. This is a moving target within any industry, but specifically cannabis. This is something that is yet to be heavily adjudicated. And I'm sure Tyler and Nate can speak more to this. But it's an area that we should all be keeping an eye on. And then the last point is that cyber insurance is truly starting to enter a hard market. And it's something that I think we're going to continue to see here for years moving forward. If you go back, 4 or 6 years, we were in a spot where it was kind of the race to the fastest application to get a policy written, right? Everything was trying to be very streamlined. When you look at cyber, let's just get it on the books. It's going to be a good risk. And now we're starting to see additional supplements. We're seeing longer applications. We're seeing penetration testing done by larger carriers when they want to understand really, the true dynamics of an account that's out there. And so I think that we're going to continue to see more stringent underwriting as it relates to the cyber risks. And we're also going to see increased pricing, decreased capacity. So that's likely the future that we're walking into right now, but that shouldn't be surprising to anybody who's paying attention to the daily news cycle, because it feels like cyber is definitely first and foremost. Go ahead to the next slide. And today's, just trends that we're seeing ransomware really drive claims payouts, funds transfers, email, computer fraud. But Javier sees a lot of this in real time, as do I, but he's a great resource. So I thought I'd pass it over, just talk high level about a couple of the ransomware and funds transfers events that may have been seen here recently.
Yeah, absolutely. Appreciate it, Mike. One thing to hit on that you were alluding to in your opening statements is basically, cyber in the past has been focused on, large professional firms that held a lot of data, financial institutions, banking institutions, higher education, et cetera. And, the brick and mortar traditional manufacturers and things of that nature really didn't have much data. So they didn't see a need for the cyber exposure and the need for the cyber insurance. And now with extortion and the fact that a lot of these organizations and brick and mortar entities now are incorporating technology significantly in order to be to operate and provide whatever it is that they're doing, it's highly susceptible to a cyber attack, which now puts them in a position where they're inoperable either entirely or partially. And then you got the loss of income element that comes along with that as well. And those are some things we'll get into relative to some of the claims we're seeing. 3 years ago, ransom, $50,000, $100,000, no problem. Here you go. Give us the data back. Now the bad actors are pulling the data out of your network, holding it for ransom. And if you don't pay their ransom, now they're basically going to release that information in the public and do it on the dark web, et cetera. And so those ransom amounts are easily starting in the 7 figures now versus, $200,000 or $300,000 in the past, and then negotiating down to $50,000 to $100,000. Now we're starting at 5, 7, 10 million and negotiating down to, low 7 figures or high 6 figures. And so even if you had a cyber policy in the past, $1 million limit, looked like everybody was fine. As long as you have something in place, great. Now your $1 million limit is being compromised just by, the extortion ransom negotiation in itself. And so there is not an industry that is immune to this. We're seeing it all across all industries, all lines of services and products, et cetera. And it really is growing significantly to the point where you're more likely to have a cyber breach than you are most other types of perils that'll, trigger other types of your policies.
So when we look at the percentage of claims by attack technique, we're still looking at this being heavily driven by email and phishing. So, as we think about it, I think that, our CEO just last week sent over probably 2 or 3 different examples of recent phishing attacks that had been seen in the industry overall. And what's pretty wild is that these are sophisticated. They're not your, misspelled, mistyped, obvious emails that are clearly fraudulent in nature. I mean, these we're starting to see requests for, hey, please open this file, take a look at this legal document that has been finalized. We need your final sign off and review to make sure that this is executed on time. These types of campaigns are getting more and more sophisticated. Some of them aren't being picked up by, internal IT programs. So, I mean, it's just awareness seems to be one of the biggest things that we can help coach our employees on, that we can help coach our business partners on, is that we all get into the habit of running so fast, I think, through our emails, so fast through our information, that it pays, especially with the way that cyber is going right now, with the sophistication of these cyber attacks, to do a second take, just do a double look at some of these emails, at some of the attachments, at some of the requests. And, there's nothing better than just quick verification. Hey, pick up the phone. Hey, Javier, did you mean to send me this document? Is this something that I should be paying attention to or on the lookout for? Simple actions like that can really help to mitigate some of the severity of these claims. So we're seeing just email phishing still being one of the fastest inroads into IT data servers, remote access, which speaks to remote desktop protocol, and then, of course, other social engineering issues. So those are going to be the primary drivers of these losses. Javi, do you want to go into a little bit more detail here on some of the social engineering that we've seen, or some of the email phishing attacks that have been seen?
Yeah, it doesn't matter how sophisticated and how much money you spend on your network security. There's still the human element in all of these. And so when we drill down into the origin of a lot of the cyber claims that we've dealt with, and we've worked with the data forensics and the other professionals on, it almost always drills back to some human error, some human element of somebody clicking or opening a document that they shouldn't have had any business opening, or there's opportunities within the system that there isn't a segregation of duties based on what your internal function is. So too many people had too much access to too many parts of the network they had no business having access to, and so when they were getting notices from different parts of their network, they're clicking on things they shouldn't have been clicking on, and ultimately giving a path in for the bad guys. So it really doesn't matter as far as social engineering. Those claims are so prevalent. It really just drills down to creating a cultural cyber security hygiene, if you would, corporate, throughout the organization, that really just, as a team, gets everybody internally to focus on the fact that this is a real life threat. We are going to have multiple cases where people are going to come after us and try to get into our network and try to extort us for the information they have, or shutting down our operations, et cetera. And so it's real, and until people really experience it, they don't really have this wake up call. And so it's just a function of before it happens to you, because it will eventually, at least the attempts will. You really have to have that cultural mindset that this is something you have to be on the lookout for and have your defense up for constantly. The social engineering aspect is, I'm not going to say it's not as relevant anymore. It's just, those costs associated with the insurable supplements of that coverage are much lower than some of the, $5 million ransom amounts that you're seeing out there. So even though they're not making the headlines as much anymore, they're still alive and real, and those are still a consistent source of where these losses are coming from.
A lot of the questions that come up are, and one of the reasons why this is particularly relevant to the cannabis industry right now is because there's a lot of personal information and new laws involving, how that's regulated, and the questions around what those regulations do and how that interplays with the coverages that you can get. So we brought in Nate Garhart to talk a little bit about the regulatory landscape in California currently and how that impacts this discussion.
Thanks, Shanti. So what I would touch on here is that Michael and Javier have talked a lot about kind of direct damages. That is, if there is a data breach, if there's a spear phishing attack, et cetera, what kind of damages can you expect to deal with, whether it's ransomware or otherwise? Well, there's another side of liability that has to be considered, and that's regulatory liability and lawsuits. And those are governed in California largely. There are other laws that apply, but the most important laws that we're dealing with right now are the California Consumer Privacy Act, which is currently in effect, and the California Privacy Rights Act, which will come into effect on January 1st, 2023, and is actually an amendment to the CCPA, the California Consumer Privacy Act. So this is the regulatory area that governs personal information and private information that's held by companies on behalf of consumers. So the first question you have to ask is, well, do these laws apply to me? Will these laws apply to me? And if you could jump to the next slide. So there are three triggers, and these are all or. So if any one of these applies to your company, then the California Consumer Privacy Act and later the Consumer Privacy Rights Act will apply to your company, and you have to adhere to its requirements. So the first is if your company has annual gross revenues of $25 million or more. Pretty clear litmus test there. The second one is if you obtain personal information, that means if you collect it directly from consumers, if you buy lists, etc. But if you collect the personal information of at least 50,000 California residents under the CCPA, or 100,000 come 2023 when the CPRA is in place, if you hit those thresholds, you'll be subject to the CCPA and later the CPRA. The third one, less likely for companies in the cannabis industry, but that would be if you're getting at least 50% of your income from your revenue from selling personal information of California residents. So this, again, doesn't really apply, isn't likely to apply to cannabis companies. This is more companies that sell lists for marketing. You may buy some of these lists, but unlikely that you're going to be selling them an amount and having it account for so much of your revenue. So if it applies, what does it mean? There are two areas to consider. The first is, and this goes away from what Michael and Javier were talking about, this is how you need to treat the private information of individual consumers. And basically, consumers get certain rights under the CCPA. First of all, they have the right to know what personal information is collected and what you do with it. Who do you share it with? You have to give them the ability to say no to the sale of that personal information. And you have to have a homepage button that enables them to click it and say, no, don't sell my personal information. Now, the word sale can be a little misleading there because it's not just selling it as far as lists, it's also sharing it with third parties that might market to them, partnerships that you have that you share information with so they can market products to those individuals. That would be selling as well, even if you're not charging money for that list. So again, people have to have the ability to say no to that. They also have to have the right to access their personal information, to know exactly what you have. And then probably most important, most heard about is the right to be forgotten. That is the right to have their information deleted. And then the second side of the law does provide for a private action for a breach. And I'll talk more about that in a bit. And just to give you a sense of how the CPRA, the California Privacy Rights Act, how that will change things in 2023, in addition to everything under the CCPA, it does have a couple of additional aspects. First is the right to correct import data. So not only do people get to see what information you have, but also they get to say, no, that's not right anymore. Please change X, Y, and Z in my information. And moreover, they can say, thank you, send that to me in a certain format, or send it to Facebook because I want Facebook to have all this information. Or more likely, they would say to Facebook, I want you to delete my information and I'd like you to send it to this given company who I'd like to have more information about me. Additionally, that right to opt out of selling button, that homepage button that says do not sell my personal information, it's now going to have two buttons, one that says do not sell my personal information, one that says do not share my personal information. And then the CPRA expands on that private right of action that I mentioned with the CCPA. So a lot of times I hear that stuff's really great about the CCPA and everything, but it doesn't apply to my company because we don't hit any of those thresholds. Well, you do have to be careful about it because at the end of the day, there are a couple of situations in which you may be subject to these requirements, even if you're not subject to the law itself. And the most simple situation is where you're under a contractual obligation. So you may be working with another company, and that company's contract with you requires that you comply with the CCPA or the CPRA. And then if that company gets sued because of your failure in connection with those requirements, they're likely to seek protection from you based on the breach of contract. So the bottom line here is just don't assume that just because you don't hit the triggers that you're not going to need to consider the CCPA and CPRA requirements. So going to jump into the data security and breaches. With that first part, with collecting the information and how you treat the information, the takeaway from that really is you need to understand the data that you have, and you need to be able to control that data. So a lot of times I'll talk to marketing folks and they'll tell me exactly what data they have. And then I talk to the IT folks and they say, no, we actually have a lot more data than that. So you really need to understand, somebody in your organization needs to understand what is all of the data and what are you doing with the data, and get that data mapped in such a way that if somebody makes a request, you can respond to that request. So moving forward to the really what we're talking about today, oh, sorry, go back one, is the data security and breaches issue. So how does this come up in these pieces of legislation? Well, it comes up in a very vague sense. First of all, the CCPA and the CPRA both say that a company has to have reasonable security procedures and practices in place. Well, you know, what is reasonable? We can talk about that a little bit. But if you don't have reasonable security procedures and practices in place and you have a breach, it does create, the laws do enable private right of action. So individual consumers can sue based on that breach, and they don't have to prove up damages. So that's the big shift here. In the past, individuals had to prove up how they were damaged and prove up those monetary damages in order to bring a suit for a data breach. Well, they don't have to do that anymore because the CCPA and CPRA provide for statutory damages. So we really get to the question then of what is reasonable then? And that has yet to be answered, but we have some things to look at. Next slide, please, Shanti. So the courts haven't looked at it yet. The best thing we have is in 2016, Kamala Harris, AG at the time, basically said that if you look at the CIS data security controls requirements, that's what you should look at, and that would necessarily be reasonable. The current AG hasn't weighed in on this. I can tell you that those 20 data security controls are pretty burdensome. It's rare that I talk to a client and the client says, yeah, we have all of that in place. So I'm not sure that all of it is going to be required or required in order to satisfy that reasonable standard, but it is a document that should be looked at. Those controls are something to look at and see what you can implement in order to satisfy this requirement. Next slide, Shanti. So what are we dealing with here? There are two areas of liability, and this goes directly to insurance questions. So I just want to call these out. First of all, if the AG doesn't like what you're doing in connection with your data collection, with your disclosures, how you're responding to consumer requests, the AG can bring an action against you and enforce, and the laws provide for damages of $2,500 to $7,500 per violation. So that can add up very quickly. I would also note it's the AG under the CCPA. Under the CPRA, there's actually going to be a new body that's created that does the enforcement. And the only reason I call that out is because under the law, that body is going to be self-funding. So it's going to rely on these damages, these fines, in order to exist and pay its salaries, et cetera. And so it's definitely going to have a significant interest in levying fines just to keep itself going. Then on the right side of the slide, you see this private right of action. Private right of action does not arise. Individuals don't get to sue based on, let's say you failed to enact their request to be forgotten. That would not lead to a private right of action or the ability for somebody to sue for that failure. On the other hand, if there is a breach and there has been unauthorized disclosure, or under the CPRA, if basically there are not sufficient protections in place and certain information is vulnerable, then a private right of action can be brought. And the statutory damages that are provided for range from $100 to $750 per data subject. Well, you know, people quickly say, well, that's not a whole lot. If somebody sues me for $750, I'll just pay them the $750. Well, as you might imagine, the problem here is class actions. And the plaintiff's bar is looking to create classes of consumers that have been, have had information breached or
I think we lost Nate for a second.
Nate
Next
had a
slide,
cyber
please, Shanti.
incident.
Okay.
During this,
we might be stuck.
Sorry, Nate, I think you're
Give it
frozen.
a second here.
Turn off your video for a second, turn it back on.
you know, while we're going through this,
We're gonna-
one thing that we could talk to, and you know, maybe Javier, you can jump into a little bit. So some of the way that these policies are written is, you know, there is defense coverage for some of this, but it won't cover what we need or what an insured needs if they're actually hit with one of these actions, right?
So there's a couple of things you go. One is there are some policies that have specific exclusions as it relates to the unlawful collecting of data, right? So you have that issue relative to a cyber policy where they will specifically not want to cover you unlawfully collecting data. And then you have the, you know, this is a lot of, you know, what Nate is speaking to is California specific. You know, California is just one jurisdiction. You know, the laws that apply are the laws of where the, in the case of a cannabis, say you're a retail shop in the cannabis industry, you know, if you've got somebody who's from Missouri or even worse from the EU who's visiting your location and you're collecting information on them, you now have to be in compliance with the rules and regulations of where that individual is from and not necessarily where you're operating as an organization. So I think a lot of people, you know, they might cite specific things local, specific to their state. However, they have to understand that it really it centers around where the residency of the individual in question is going to, and those rules and those regulations are going to apply.
I think we'll move on to, you know, what happens when you actually have a breach, and Javier can talk to us a little bit more about how that works.
So what we like to call an anatomy of a data breach, so to speak, but in general, you know, and it's been like this for a while. If you have a breach, you've realized that your information your systems may have been compromised, or information within your systems may have been compromised, or also a vendor whose information you've entrusted has been compromised. And in most cases, in the laws that state, is whoever collected the data is responsible of maintaining that data and is responsible of doing so, so that data is not exposed, et cetera. But also that obligation to notify those individuals that may have been impacted is now borne onto the organization that collected the data, regardless of who the organization decided to give that data to for whatever reason, for processing, for payment processing, it doesn't really matter. And so the anatomy of a data breach, you have a data breach. You know, in general, if you have a cyber policy, you're going to notify your cyber insurance carrier, and then they are going to hire, in most cases, a data breach coach, which is usually a law firm that's got experience in all of these various jurisdictions and regulations, whether it's the EU, whether it's New York, whether it's California, Florida, and they're all varying. They all have different rules and regs that you must comply and take in consideration. And so the breach coach will come in and help analyze the situation. And then you're going to have the forensics, IT forensics come in, look at your network, find out what happened, when did it happen, why did it happen, is it still happening, what information was compromised, et cetera. And then from there, you can determine if there were violations or if there were certain states that call for various actions, whether it be notification, credit monitoring, identity restoration, et cetera. There's, you know, then you and a data breach coach along with your insurance company would make a determination of the best way to go about notifying those individuals. What you're doing, and those are, you know, You'd be surprised at how many of our insureds come to us, tell us they have a situation. We know damn well they have a situation, and we never hear from them again because they decided to just bury their head in the sand, right? And so there is that option. So the option where you notify your carrier and let the professionals handle it is one, but you do have to understand you do have actual duties legally in most jurisdictions to do something about it. And at a minimum, it's going to be from a notification perspective. So you have to assess the extent of the breach, perform forensics, notify the appropriate authorities. I mean, it's wide. I mean, even like in New Jersey, the state police want to be notified of an event, right? In addition to the FBI, in addition to the Office of Civil Rights, if it's healthcare related. I mean, you've got literally a laundry list of regulatory bodies that are going to be notified in any given situation. Go to the next slide, Shanti.
Sorry.
It's okay. So this slide, I'm not going to go through in detail. It's just getting back to my point. There are so many regs and rules and things that you need to comply with, regardless of where you're located. It's where the individual in question was located, and you really need to hire, a law firm who's got extensive experience in handling these, knows what the ins and outs are of these jurisdictions, and it also determines on the type of data. Healthcare data is one function, financial information is another, consumer information is another. And so there's really, depending on the breach and the location and the number of individuals and where they reside is all going to come into consideration when you're determining how to respond to a breach and notify these individuals to be in compliance with each of those states or jurisdictions that they reside in. So short version is you got to rely on the policy, and you got to rely on the professional data breach coach, law firms that can come in and help guide you through that situation.
Thanks, Javier. Now we're going to get a little bit more into the nitty gritty of what the cyber coverage actually is and what you should be looking for. So, Michael?
Yeah, sure. So as we look through, insurance overall for the cannabis industry, one thing that I always bring up with the agents with whom we work is that this is a highly segmented insurance market. I mean, we're not in a place where you can pick up a phone, take 15 or 20 minutes and get your insured a full package policy that's going to include all the coverage forms that they need to be operational. And this slide, even though we're dialing in specifically to cyber, we wanted to bring this up, twofold. One, to show that there are a number of different insurance coverages that are required for each type of cannabis operation within the vertical. The other is that you have a very detailed supply chain. And many parts of the supply chain can be affected by data breach, especially with the technology that's being utilized. And the third part is that occasionally we'll see cyber embedded or sublimated onto a policy that's not cyber standalone. It's not a monoline cyber policy. You can go to the next page, Shanti. So when we're looking at these policies overall, we're in a unique position where there's only a handful of companies that'll actually write a monoline cyber policy. And when we're looking at those, if there is coverage under a general liability policy or another policy for cyber, we want to start to dig into and look at whether or not we have primary wording on those, who's going to take over in the event of a data breach of a claim. And we really want to make sure that we piece those policies together to trigger and respond in the proper way. So on our next slide, Tyler's going to jump into some of the specifics of the coverage form of a cyber policy, the reasons for it, and of course, why cannabis companies specifically need those. So Tyler, I'll go ahead and pass it over to you.
Thanks, Michael. Shanti, maybe we can skip to the next slide. Okay, there we go. So first, before getting into the specific issues that cannabis companies may be seeing, and I thought I'd briefly describe basically what these policies, what a cyber insurance policy would cover. And all cyber insurance policies are different. Each carrier has its own form. They're non-standard. They're negotiable, or at least they used to be negotiable. You need to be reviewing it very carefully before you buy it in order to ensure that it covers what you want and need it to cover. But they are a combination of essentially two things. Just like Michael and Javier were discussing, cyber insurance policy will cover certain of your losses, direct losses resulting from a data security incident, whether it's a data breach or hack or a ransomware attack or something like that. And when I say direct losses, what I'm talking about is what we call first party loss, which means money you have lost directly as a result of the cyber event. These can include, and they're listed here, is your response costs, that is forensic investigation costs, as well as attorney's fees, cost to notify consumers, cost to provide credit monitoring, identity theft monitoring. It can also cover lost net profit, as well as what we call extra expense, which is basically additional expense you incur to try to mitigate your lost profits. It can also cover normally ransomware or extortion payments, and even the cost of restoring data that was damaged or destroyed in an attack, or even repair or replacement of computer hardware, what we call bricking. If it can't be repaired, some of these policies will cover its replacement. Not all, though. Some of these coverages are kind of standard, like the data breach response costs. Coverage like bricking is not necessarily standard. It's something you can negotiate into the policy. They also cover, so those first party losses you directly incurred as a result of an event. They also cover liability claims, as was discussed before. They'll cover your defense costs and damages or settlements in class actions arising from a data breach. They'll cover often regulatory action, so an action by the state attorney general, your at least defense costs. And they'll often say that they cover fines or penalties assessed against you. But whether the insurer is allowed to provide that coverage is subject to state law. And many states, including California, have sort of a complex approach to whether certain fines and penalties can be covered by an insurance company. And there's particular language you can negotiate into the policy to sort of increase your odds of being able to get coverage for a fine or penalty by the state attorney general, for example, under the CCPA, by allowing you to hopefully like kind of reach outside of California and grab another state's law and use it in arguing for coverage. But like Javier said a few minutes ago, it is questionable about whether you can get coverage for a non-breach, a lawsuit arising out of something other than a data breach. So if you're being sued for wrongful collection of information, failure to delete information that you're required to delete, wrongful transfer, sale of information, that's kind of a gray area in these policies. And there are lawsuits for those things. Nate mentioned that earlier that under the CCPA, technically speaking, the law says that private plaintiffs, as opposed to the attorney general, private plaintiffs cannot sue for anything other than a data breach. But more than 50% of class action suits that we've seen filed in California since the CCPA came into effect didn't involve a data breach, but they allege violation of the CCPA. A lot of the policies out there either do not clearly provide a defense for that kind of thing, or they simply don't provide a defense at all. And so that's one area where you'd want to be very careful about negotiating the wording of your insurance policy and trying to expand the coverage. Also, you can get cyber policy, you can get media liability policy coverage, which will give you coverage for like IP claims other than patent infringement, privacy violations, that kind of thing. So basically, you can get a smattering of different coverages, but you need to be paying attention to what you are concerned about or what you should be concerned about, and making sure that it gives you the coverage that you want and need. And in just a moment, we'll talk about specifically some issues for cannabis companies that are either tricky or you should be watching out for in the cyber insurance policy. So maybe we can flip to the next one, Shanti. Oh, there we go.
If you're going,
Yeah.
this one, the key issues.
Yeah, maybe I'll ask Javier and Michael, are we good with doing this slide? And then go into questions, or is there something you want to add before we get to this topic?
I think to hit on your point where, there are several options out there in general for cyber. For the cannabis industry, our efforts have focused to 2 or 3 actual insurance companies that are actively writing primary insurance coverage for entities in the cannabis industry. And even one of those companies has a revenue threshold that can't go more than 100 million in some cases, depending on the nature of operations. And so it's a very limited marketplace, and the negotiations is very difficult. Beggars can't be choosers, so to speak. And so one thing to consider is, a lot of these policies were centered around notification, credit monitoring, identity restoration. You really, as an organization, you have to take what you think is your biggest exposure to cyber. We had a dispensary call us and say, hey, we want to start doing a rewards program, which is going to require collecting various information at the point of sale, which would potentially conflict with the Song-Beverly Act in California specifically. And then, going about how you're collecting that data, what you're doing with that data. And then there's own statutory fines and penalties associated with that. And then there's a large conversation in the underwriting community as to whether or not those would actually be covered. And again, you have a non-data breach issue surrounding the collection of data, dissemination of data, the use of that data, and whether or not your cyber policy would actually respond to that. And in this particular case, the organization just made a determination, like, for right now, until we know more, this rewards program isn't worth it to us. And
yeah,
so
that's
those are consideration.
Yeah, and that's a really good example. I mean, these policies often will eliminate coverage for violation of certain consumer protection laws, or either unspecified consumer protection laws. Just generally, they'll eliminate coverage for certain contractual liability or indemnification obligations that you may have. So you just need to read the fine print, or have somebody read the fine print very closely. Particularly if you're concerned about, well, I agreed to indemnify my supplier in this contract. What if we had a breach? If they require me to indemnify them, would I be covered for that? You really got to look at the policies. Some policies would say yes, some would say no. And so we'll run through just a few issues that we see as being sort of real issues for cannabis companies. One is property damage. So we've all seen the Colonial Pipeline attack in the news. There were prior attacks that affected property or damaged property. There, a few years back, there was an attack in Ukraine that took out a steel manufacturing plant. There have been other attacks that caused property damage because basically companies are operating their industrial systems with computers, and the computers get hacked, and the hackers will either intentionally shut them down in order to damage property, or it's sort of a byproduct of the attack itself. Here, if growers are using computer systems to monitor or to regulate, watering systems, that kind of thing, if there's an attack and it basically prevents the company from being able to do what it needs to do with its crops, and that damages the crops, the cyber insurance policy probably will not cover the damage to the crops. And then you have to wonder whether your crop insurance, if you have crop insurance, would cover that damage. And it probably won't, because it probably has a cyber exclusion in it. I can see Michael nodding there. Mm-hmm. So that's one area where a production company could fall between the cracks, essentially.
Yeah, and to that point, if there's parts of your system, getting back to a cultivator and whether or not they're using another third party's technology in order to help monitor what they're doing for their own crops, et cetera, or excuse me, I have a phone call over here apparently. But if they are using technology to, monitor certain parts of the grow aspect of their operations, and if they're relying on a third-party vendor, technology service provider to provide them with, let's call it a software as a service or platform as a service, and that vendor is breached, rendering your operations inoperable or partially inoperable, then there are certain elements of coverage that could be triggered under the contingent business interruption element of one of these policies. We had a situation where a server farm was struck by lightning in West Texas. The server farm is down for, I want to say 3, 4, or 5 days at a minimum. And we had multiple insureds calling us wanting to report an incident that they were unable to obtain their data and basically operate because this server farm was shut down. Their data was inaccessible for a period of time, for which they wanted to know whether or not they were able to collect a business interruption income loss element of coverage under their cyber policy. And in that particular case, there was some coverage, and I think the vendor in question actually decided to indemnify them to a certain extent, as a PR move, so to speak. But you also have to look at your operations as a cannabis company and decide, what part of my operations is contingent upon technology that's offered by an outside vendor, and what plans do you have to respond in case they're breached or have a systems disruption issue for which you're not prepared for, and what redundancies do you have in order to respond to that?
Right, and in recent years, the coverage in this area has expanded greatly. It used to be just limited to an attack, a cyber attack on your own computer system that causes business interruption. Now it could be an attack on a third-party system, or it could be an error on your system or a third-party system that causes the outage. It's much broader, but then you have situations where there's either property damage or there's some other thing going on with the attack or incident that would kick you out of coverage. Another area where cannabis, I think, well, particularly retailers, but other businesses in the cannabis industry could have an issue is with trust of their buyers. Cannabis businesses collect highly sensitive information of people. So not just credit cards, but some will be collecting like driver's license numbers, personal health information, just the fact that a person bought their product, that may be sort of viewed differently than if they're out buying something on Amazon. And they wouldn't want that to become public. So cyber insurance does cover sometimes, depending on the policy, but some cyber insurance policies cover reputational harm, that is lost business due to a cyber event. That is, you get a breach, you have to notify consumers, it becomes public, and then people don't want to do business with you anymore. There can be a certain period of time built into some of these policies for lost profits, basically, as a result of that. Not because your system's down, but because people aren't buying from you anymore. That would be a particularly important coverage to get if it's available at the time when you're seeking to buy it. Relatedly, and this is something that Javier and Michael raised in our discussions about preparing for this presentation, which is cannabis businesses also may face sort of a limits issue with policy limits issue with the cyber insurance that they have, because they may be, because of the sensitivity relating to the information that they're holding, they may be subject to more lawsuits, more higher profile lawsuits, and or lawsuits that seek sort of greater damages due to the reputational harm caused to their customers as a result of the breach. We saw this in the Ashley Madison breach. It must have been almost 5 years ago now, 4 or 5 years ago now, where just the fact that somebody's name was associated with a company caused the lawsuits and the liability exposure to sort of skyrocket. And quickly, these policies get eaten up by defense costs, because the defense costs that are spent in defending a lawsuit, erode the limit of the policy. And so you could basically spend all your limits in defending a case and then have nothing left for a settlement or judgment at the end. And then finally, particular to the cannabis issue, there may be federal regulatory scrutiny. And in this industry, of course, we want to, we get nervous when we say federal regulatory scrutiny. So these policies often will cover federal regulatory investigations and actions, but it's something kind of particular to this industry where you want to be cognizant of that risk and what the policy might do in response. And I actually asked Michael and Javier if the policies that are sold to cannabis businesses that you're saying with these 2 or 3, if they're sort of targeting, if they would cover that kind of thing or not. I actually don't know the answer to that, but it's something you'd want to review really closely.
Yeah, I think it would depend on the nature of the breach and the information in question. But we get this question, what additional regulatory scrutiny would cannabis industry have from a cyber security perspective? Inherently they're collecting some version of healthcare information. You got you got HIPAA laws that are at a federal level, and do they apply to operations that are not really accepted federally, so to speak, right? They haven't been approved, and they might be approved at a state level. So at a minimum, you probably would anticipate coverage for the state regulators and the issues that they might have with your network security or lack thereof as it relates to a breach, in particular if there's healthcare information. But and speaking with the some of the national breach response firms, they basically stated, listen, if you're going to have to comply with a state required notification, you're probably in compliance with a HIPAA notification as well. And so you've kind of already, killed 2 birds with 1 stone, so to speak. And if you have a lot of healthcare information, you are worried about HIPAA. And I don't know that there is any, that there is a census that it would apply, but at least gathering that information so that if somebody, did come knocking on your door and wanted to review what you did with that information, how was it protected and how did you respond to it? You probably should have some analysis of what you did and how you responded to it in order to provide them with some information if they were to come, question what your response was to a particular breach, especially if it got out in public and, now the feds are looking into it.
And we have a couple more minutes.
Yeah, we've got a few questions that have already come up in the chat as well. One of which is that it seems like the retail dispensaries have the highest cyber exposure, but have you seen claim activity increase with wholesalers, processors, extractors? What kind of claims are you seeing higher up the production chain?
So relative to cultivators and wholesalers, again, the issue with them is not data. Dispensaries have data, which people can do stuff with. But for the wholesalers and cultivators, if their systems are largely dependent upon technology, getting to their systems and shutting them down and encrypting them out of their own systems, which effectively is rendering them inoperable, that's where the money is for the bad guys, right? So then they can hold and hold your systems for an extortion where you literally can't have access to your own systems to start cultivating or distributing your product. Then you're in a situation where you're going to be left to, pay that ransom, or you better have a redundant, system in place that you can switch over to in order to mitigate that situation. And along with that is the data. If you have backups, make sure they work, because those backups is what you're going to go to and you're going to rely on in order to get back up and running, or whatever your redundant system is in place. And so you got to have a data breach plan, response plan in place. What would you do if these 3 scenarios went down, and test it and make sure those measures can be implemented effectively so that you don't have to pay that extortion, or you pay an amount that's much less because that, is much less important to you. But that's where I see the claims for the cultivators and wholesalers is relative to the how reliant they are on the technology that they're now using.
Mm-hmm. And then our last point was some mitigation risk strategies, but also I just wanted to remind everyone that we are planning to stick around for at least 10 to 15 minutes after at the end of the presentation, if anyone has questions, we will be here. But
So to jump in really quick, what to do to help your cause, multi-factor or dual factor authentication, in the underwriting process, it's basically a must. I mean, if you don't have that in place at a minimum for your email, it's just a non-starter for most insurance companies. You will get a declination. You will be non-renewed at your renewal. They are very seriously considering, who doesn't have multi-factor authentication. And it's not just for email. It's also for internally, admin access to your systems, et cetera. And then, financial access to your accounts and the like. And so multi-factor authentication, I'm not going to say it's number one, but which one or 1A for sure. EDR, endpoint detection and response. This is typically a software that's available that can be deployed on each endpoint, whether it's a laptop or server or desktop. It's relatively inexpensive, but it's not as complicated to deploy and make part of your network security, but it is another feature that these insurance companies are looking for so that in real time, a potential threat can be identified, can be analyzed, and then they can the actual software can detain it or eliminate it and, make the rest of your network aware of a situation that's occurred on Tommy's laptop at home, right? Employee training, again, getting back to what we said before, the human element and the human error is most likely the cause of probably 80+% of the breaches that we see. And you'd be surprised at how basic these attacks really are as far as the format and how easy it is for people to just click on the wrong thing and input some basic information. And then, voila, these guys are in and now you've been exposed. Backups are critical. Getting back to where insurance companies are seeing a lot of losses today, not the notification, not as much regulatory yet, that's coming, but the business interruption element, because somebody says, yeah, I got my information backed up, but they haven't tested it. So when they get breached and they have to go back it up, they realize that their systems aren't backed up as effectively as they thought, and it's going to take longer in order to get them back up. And now you're out of operations for a longer period of time. And now your business interruption element has just increased, tenfold. So you got $100 million company that's out for 5, 6, 7 days. That's a real number as far as a business income loss. And so the frequency of your backup and also the segregation of your backup so that's not online along with the rest of your network is very important. And then I'll just jump to the breach response plan. Again, have one, make sure you've tested it, and you'd be surprised how many people call us and say, hey, we've had a breach and our systems are locked up and we don't know what to do next because our breach response plan is only saved electronically and it's part of the breach. And so we don't have access to it. So have a physical manual copy of your breach response plan and make sure your appropriate executive management team has a copy of it, a physical copy, because once you're locked out of your systems, you won't have access to it.
At least they're calling you, though. That's a good thing, because one of the first things on the breach response plan should be to call the insurance company, as costs incurred before the insurance company is notified typically are not going to be covered. So I'd
Correct.
love to end the presentation on that point every time if I can.
notify. Yeah.
Yep.
Thank you, everyone, for joining us.